In 1996, a group of villagers from a really remote, heavily forested region of Myanmar, they did something that, well, on paper, it should have been completely impossible.
Right. Almost legally unthinkable at the time.
Exactly. I mean, they were armed with nothing but this obscure, like, single paragraph law from the 18th century.
Yeah, from 1789.
Right, a law originally written by the first United States Congress to prosecute pirates on the high seas. And with that, they dragged one of the wealthiest oil conglomerates in California into a U.S. federal court.
And, they weren't suing over a bad contract or like a spilled barrel of oil or something
No,
standard.
no, they were taking a massive multinational corporation to court over human rights abuses. Abuses committed by a foreign army on foreign soil, literally thousands of miles away from American jurisdiction.
It is arguably one of the most audacious legal maneuvers in modern corporate history.
Yeah.
And what makes it so critical for us to examine today is that it wasn't just, a quirk of the legal system. It was this inevitable collision, the collision between the sheer permanence of global energy infrastructure and the shifting, often brutal realities of state power.
That is exactly what we're focusing on today. If you follow our work, you know this is a deep dive into a heavily researched dossier compiled for the Global Blueprint, which is our sibling series to Backyard Empire.
Right.
Today, we're unpacking the Yadana gas project in Myanmar, which was historically known as Burma.
Yeah, and we're tracking a timeline that really starts in the early 1990s and burns right up to 2022.
So our mission for this deep dive is to understand the actual mechanics of what happens when a foreign corporation fuses with an authoritarian state to build and run strategic infrastructure.
And we are going to look at those mechanics strictly through the facts. We are synthesizing, honestly, thousands of pages of court records, historical filings, human rights documentation from organizations like Earthrights and the corporate records of the energy companies themselves.
Right, because the goal here isn't to just judge the past, but to understand the specific legal, financial, and physical structures that made this partnership possible.
Exactly. And why it ultimately triggered a legal reckoning that, frankly, altered the DNA of global corporate liability.
We have a massive amount of ground to cover today. So we're going to start by looking at the geopolitical chessboard of the 1990s, just to see why Western energy giants formed a joint venture with the Burmese military regime in the first place.
Yeah, setting that stage is crucial.
Then we have to look at the physical reality of building a pipeline. Specifically, how the Burmese army effectively became, well, a private security force for a corporate asset.
And that causal link is what leads us directly into the Doe v. Unocal lawsuit.
Right, the piracy law maneuver we just mentioned, which changed the landscape of litigation forever. And finally, we will bring it to the modern era. The 2021 military coup, the 2022 corporate withdrawal, and this incredibly complex, paradoxical dilemma of, how a company attempts to exit a dictatorship when the contracts are explicitly designed to lock them in.
It's a profound structural puzzle. Truly.
It is. So let's jump in. To understand the opening moves, I think we have to look at the economic reality of Myanmar in the early 1990s.
Yeah, and to put it mildly, the country was in a state of severe economic isolation.
Understatement of the century.
Right. The military junta, known as the Tatmadaw, had absolute control, and their domestic policies, combined with heavy international sanctions, had largely cut them off from the global financial system.
Right. They're dealing with the hangover of decades of isolationist policy. They're cash poor, they're technologically isolated, and politically radioactive to most of the Western world.
Exactly. And this is the fulcrum of the whole story. They were sitting on an incredibly strategic, massively valuable geological asset.
The Yadana natural gas field.
Yes. It lies in the Andaman Sea, roughly 60 kilometers off the coast of Myanmar.
And geologically, it was just a massive find.
Huge. And the state-owned entity, the Myanmar Oil and Gas Enterprise, or MOGE, they theoretically owned the rights to this gas. It was their sovereign resource. But, as you know, recognizing you have a resource and actually monetizing it are two entirely different universes in the energy sector.
Oh, absolutely. Because extracting natural gas from the ocean floor is, it's one of the most capital-intensive, technologically punishing endeavors on the planet.
It really is. You don't just, sink a pipe and wait for the money to roll in.
No. You need deep water drilling platforms that cost billions to engineer. You need subsea architecture to manage these incredible atmospheric pressures down there.
And you need to lay miles of reinforced pipeline across the ocean floor.
Right, bring it ashore and then run it through dense tropical terrain just to actually deliver the gas to a buyer. It's an engineering nightmare.
Exactly. The capital expenditure, the capex required for a project of this magnitude, it runs into the billions of dollars before a single cubic foot of gas is ever sold.
And MOGE just had none of that capital.
None. They had no capital, they had none of the deep-sea extraction technology, and they completely lacked the specialized engineering expertise required to execute the logistics.
It's like finding a gold mine in your backyard, but all you have is a plastic spoon.
That's a great way to put it. They were locked out of their own vault.
So their only play is to syndicate the risk. They have to go to the global market, find the entities that do have the billions in capital and the proprietary technology, and invite them in.
And because MOE is operating from a position of profound infrastructural weakness, they really have to offer up a highly lucrative joint venture.
Which brings us to the consortium that was formed to exploit the Yadana field. The junta opens the doors, and this very specific architecture of international capital steps through.
Let's lay out the structural chart of this consortium, because the way these companies are layered is vital to understanding the legal fallout later on.
Yeah, let's break down the players.
So the primary player, taking the role of the operator, was the French energy giant Total, which operates today as TotalEnergies.
And just to clarify for the listener, in the oil and gas world, the operator is the entity with their hands on the actual machinery, right?
Exactly. They manage the day-to-day engineering, the construction logistics, the hiring of subcontractors, the physical extraction process. So they took the largest private equity stake in the project.
Then you have the American muscle, Unocal.
Right. Unocal was a massive California-based oil exploration company, and they came in as a major financial stakeholder.
So they aren't turning the wrenches like Total.
No, but their capital is absolutely critical to funding that multi-billion-dollar build-out. And it's a very important footnote for our timeline that Unocal was later acquired by Chevron in 2005.
Right, meaning Chevron ultimately inherited this entire position.
Correct. Now, alongside the French and the Americans, you have the buyer.
Because you have to sell this gas to someone.
Exactly. The entire economic logic of a Yadana field was to pipe the gas directly into neighboring Thailand to feed their booming industrial energy grid.
Okay, so Thailand comes to the table.
Yes. Thailand's state oil firm, PT joins the consortium. They act as both a project partner and the primary customer.
Got it.
And finally, you have MOGE, the Burmese state enterprise, acting as the host partner, basically holding a stake on behalf of the military regime.
Okay, if you look at this through the historical lens we use on the show, this structure is just a fascinating evolution.
It really is.
Because if you go back to the mid-20th century, like we talked about with the United Fruit Company in Guatemala or ITT in Keeler, you see this model of unilateral corporate imperialism.
Right, the classic model.
Yeah, it was one American company flying the American flag, going into a foreign country, and essentially carving out a sovereign enclave for itself. They built their own company towns, ran their own rail lines, and just dominated the host government single-handedly.
But the Yadana project represents something entirely different.
Right.
It is a highly evolved, syndicated model of extraction. The risk and the political exposure are distributed across this multinational chimera.
I like that word, chimera. It's a mix.
Yeah, you have French engineering, American capital, a Thai consumer market, and a Burmese military host, all walking together around a single piece of physical infrastructure.
The pipeline itself is the fusion point.
Exactly. The flags are mixed, which theoretically diffuses liability and makes the project incredibly resilient to pressure from any single government.
It's brilliant from a risk management perspective. But it creates a profound logistical reality on the ground. Because, once that ink is dry on the joint operating agreement, the abstract world of international finance crashes into the physical geography of Myanmar.
Right. You have to actually build the thing.
Yeah, and the onshore portion of the Yadana pipeline had to cut directly through the Tenasserim region. This is dense, rugged terrain, and critically, it is the historical homeland of the Karen ethnic minority,
who had been locked in a bitter, decades-long armed conflict with the central Burmese military.
And this is where the mechanics of infrastructure demand a localized monopoly on violence. To lay a massive pipeline through contested territory, you require absolute control of the corridor.
You have to clear the jungle, build access roads for heavy machinery, establish logistics bases, and above all, you have to guarantee the physical security of an asset worth billions of dollars.
And the joint venture agreement explicitly addressed this, didn't it? The contract required MOGE and, by extension, the Burmese military to provide the security for the pipeline's construction and operation.
Yes. The Tatmadaw became the designated security force for the corporate consortium.
Wow.
And to understand what that actually meant, we have to look closely at the documentation compiled by human rights investigators and later presented in court. The Tatmadaw did not secure this region using, standard corporate perimeter defense tactics.
Right.
They secured it through martial pacification.
Okay, let's be very specific about the mechanics of this pacification. Because forced labor is a term that gets thrown around, and I feel like it can sometimes lose its impact. We aren't talking about predatory labor contracts or underpaid workers here.
No, absolutely not. We are talking about state-sanctioned coercion.
Yeah.
According to the synthesized reports from groups like Earth Rights International, military battalions entered Karen villages in the pipeline corridor and forced the inhabitants to act as unpaid logistical support for the army guarding the project.
It's just staggering to think about.
Villagers were conscripted at gunpoint to act as porters, literally carrying heavy military equipment and construction supplies through the jungle. They were forced to physically clear the land for the access roads.
And the brutality used to enforce this was systemic. The historical record points to a horrific pattern of violence utilized to maintain that security perimeter. We're talking about documented instances of summary executions, systemic rape, torture, and the forced relocation of entire villages.
Yes.
The military essentially raised the human geography of the corridor to create a sterilized zone for the pipeline to pass through.
That's a very accurate, sober assessment of the factual record.
Now, I have to push back here, or at least play devil's advocate on behalf of the corporate boardrooms in Paris and California.
Okay, sure.
If you are Total or Unocal, you have practically infinite resources. You have the capital to hire the most elite private security contractors on the planet. Why on earth would you rely on a state military that is internationally infamous for human rights abuses?
It's a fair question.
Right. Why not just fly in a private security firm, set up your own perimeter, and keep your hands totally clean?
It is a very logical question from a Western corporate perspective, but it fundamentally misunderstands the nature of sovereignty in an authoritarian state.
Okay, unpack that for me.
If we look back at the United Fruit model in Latin America, those corporations operated in relatively weak states where the government effectively ceded its sovereignty to the company.
Right, the classic banana republic dynamic where the corporation is the biggest bully in the yard.
Exactly. In some cases, the corporation did act as its own state or could call upon the U.S. government to intervene. But the Burmese junta in the 1990s was fiercely nationalistic and deeply paranoid about foreign intervention.
Oh, I see.
They possessed a massive, heavily armed, standing army. They were never, under any circumstances, going to allow a Western corporation to import an independent, armed mercenary force into their sovereign territory.
They would see it as an invasion.
Exactly. In a dictatorship, the state demands an absolute monopoly on violence. The junta dictated the terms of entry. If you want the gas, you use our military for security.
So the corporations are trapped by the sovereignty of their host.
Yeah.
But it creates this deeply symbiotic relationship, doesn't it? The corporation requires the military to physically clear the path and silence opposition so the pipeline can be built, but simultaneously, the military requires the corporation.
It goes both ways.
Right. The sheer presence of these Western giants, the massive influx of foreign capital, and the promise of future gas revenues, it provides the exact financial oxygen the military needs to sustain itself. The infrastructure literally cements the bond between them.
It is a closed loop.
Yeah.
The asset sustains the army, and the army secures the asset. And historically, this type of closed loop is legally impenetrable.
Because of state sovereignty?
It's exactly. When a sovereign military commits atrocities within its own borders against its own citizens, international law is notoriously weak. The concept of state sovereignty acts as an iron shield. A government generally cannot be easily dragged into a foreign court for its internal domestic actions.
Which is why the events of 1996 are so structurally fascinating.
Yeah.
Because that impenetrable shield of state sovereignty was bypassed using a completely different legal vector.
Yes.
And that brings us to the reckoning, the Doe v. Unocal lawsuit.
To understand the mechanics of this lawsuit, we have to look at the specific legal tool the plaintiffs utilized, the Alien Tort Statute, or ATS.
Okay, let's dive into the ATS, because this is where the legal history gets really wild. You have a law that was passed in 1789. George Washington is president. The ink on the Constitution is barely dry. What did the first Congress actually write, and why?
The Alien Tort Statute is remarkably brief. It essentially states that U.S. federal courts have jurisdiction over any civil action brought by an alien, meaning a non-U.S. citizen, for a tort, which is a civil wrong, committed in violation of the law of nations or a treaty of the United States.
The law of nations. That's such an 18th century phrasing.
It really is. In 1789, the young United States was terrified of being dragged into international conflicts because it couldn't control the actions of individuals within its borders.
They were trying to prove they were a real country that followed the rules.
Exactly. The law of nations primarily referred to things like piracy on the high seas or the assault of a foreign ambassador. The statute was basically a mechanism to say if a foreign citizen is wronged in a way that violates universal international norms, our federal courts will hear the case so we can show the world we respect the rule of law.
So it was designed for pirates and diplomats.
Pretty much.
And then it essentially sat dormant in the legal archives for almost 200 years. But then, in the 1980s, human rights lawyers dusted it off and started using it to sue foreign dictators or torturers who happened to visit the United States.
Right, that was the first revival of the law.
They argued that modern human rights abuses like torture or slavery were the modern equivalent of piracy. They were violations of the law of nations.
That was the first major leap. But Doe v. Unocal represented a second, even more massive legal leap.
How so?
Well, the plaintiffs, in this case the Karen villagers, operating under the pseudonym Doe to protect their identities, they weren't suing a foreign dictator who had traveled to the U.S. They were suing a U.S. corporation.
Oh, right.
They were arguing that Unocal, an American legal entity, was complicit in the human rights abuses committed by the Burmese military, and therefore Unocal was liable under the Alien Tort Statute.
Just wrap your mind around the audacity of that argument. You are attempting to pierce the corporate veil across international borders, bypassing the sovereign immunity of the Burmese state by arguing that an American oil company is legally responsible for the actions of a foreign army, all based on a law written during the French Revolution.
It's a legal moonshot.
Absolutely.
And Unocal's defense, logically, was that this was an absurd overreach. Their primary argument was rooted in the mechanics of the joint venture. They argued that they were merely investors. Total was the operator. The Burmese military was a sovereign state actor.
We just wrote the checks?
Essentially, yes.
Yeah.
Unocal asserted they had no control over the Tatmadaw, they didn't issue military orders, and therefore they could not be held legally liable for the military's actions.
And so the litigation grinds on for years. Massive jurisdictional battles, discovery phases, motions to dismiss. But then in 2002, a major breakthrough occurs. The Ninth Circuit Court of Appeals, which is a massive federal appellate court in the U.S., issues a ruling that sends absolute shockwaves through global corporate boardrooms.
It did. They ruled that the case could officially proceed to trial.
And the specific language the court used in that 2002 ruling is the linchpin of modern corporate liability.
Yes, the court found that there was sufficient evidence to suggest that Unocal knew of and benefited from the forced labor being utilized by the Tatmadaw.
Knew of and benefited from. Let's stop and examine this exact phrasing, because the distinction here is everything. The court did not say that Unocal executives sat in a boardroom in California and drafted a memo saying, go enslave these specific villages to build our access road.
Right, they didn't direct the atrocities.
Exactly.
This is a crucial clarification of the factual record. The court explicitly separated the concept of knowing and benefiting from the concept of directing or ordering. It did not establish that the company directed the Army's abuses.
So why does that matter? Let me try an analogy here to explain the shift in liability to the listener.
Go for it.
Imagine you manage a complex global supply chain for a clothing company. You hire a factory in another country to produce your shirts. You don't tell the factory manager to lock the fire doors or use child labor. You just demand a certain quota at a certain price.
Right.
But if you send inspectors to that factory and you know the fire doors are locked and you know children are operating the machines and you continue to buy the cheap shirts anyway, meaning you're financially benefiting from that illicit setup, you can't just throw your hands up and say, well, I didn't give the order.
No, you can't.
The Ninth Circuit was essentially applying that logic to international infrastructure.
That is an excellent structural comparison. The legal precedent established here is that a corporation cannot simply hide behind the defense of independent state action. If you enter into a partnership with a sovereign entity, and you are aware that this entity is utilizing systemic human rights abuses to further the goals of your joint project, and your project operationally or financially benefits from those abuses, such as having your pipeline corridor cleared and secured, you may be held legally complicit in a U.S. court.
It effectively weaponized human rights due diligence. It said to corporations, ignorance is no longer a defense, and outsourcing the violence to the state doesn't wash your hands.
Exactly.
So Unocal is staring down the barrel of a highly public, precedent-setting federal trial where the entire operational history of the Yadana pipeline is going to be dissected in front of a jury. What happens?
In 2005, Unocal settled the case.
They settled out of court. They essentially bought their way out of the trial.
Yes. They agreed to a settlement that provided financial compensation to the survivors and funded programs to improve living conditions in the region. Now, it is critical to state that a settlement is not a formal admission of legal guilt. The law was not definitively tested in a final jury verdict. However, the practical, historical outcome was revolutionary.
It proved that the legal theory worked. It was among the very first times in history that a multinational corporation paid compensation in a corporate human rights case of this magnitude.
If we connect this to the broader trajectory of the global blueprint archives, the legacy of Doe v. Unocal is monumental. It became the direct ancestor to almost all modern corporate human rights litigation.
Oh, absolutely.
Think of the Chiquita and AUC verdict we covered, where a massive agricultural company was held liable for funding paramilitary death squads in Colombia to protect its banana plantations.
Right, or the Chalk v. Hudbay litigation in Canada dealing with mining abuses in Guatemala.
Exactly. Those legal avenues, those specific strategies of piercing the corporate veil to hold parent companies accountable for international abuses were heavily paved by the Yadana precedent.
But wait, I have a massive structural question here. The lawsuit was against Unocal. Unocal was the American partner providing capital. What about Total? Total was the French company, and they were the actual operator of the project.
Right, the ones on the ground.
Yeah, they were the ones with engineers on the ground managing the day-to-day logistics. How did the operator avoid the lawsuit while the investor caught the heat?
This is a highly contested point regarding complicity within the dossier, and it comes down to the strict mechanics of international jurisdiction.
Okay, explain that.
The American legal system possessed the Alien Tort Statute, which provided a very unique, albeit ancient, gateway for foreign plaintiffs to sue in a U.S. federal court. Total, as a French entity with its primary operations in Europe, was outside the immediate jurisdictional reach of that specific U.S. framework.
So it's a quirk of legal geography. The American legal system had a pirate law loophole, and the French system didn't.
The French civil law system operates very differently from the American common law system. Total did face severe scrutiny, massive public protests, and separate legal challenges within France regarding their role as the operator.
Okay, so they weren't totally ignored.
No, not at all. But the legal architecture in France at that time did not provide the same aggressive avenue for transnational tort liability as the ATS did in America. This divergence sparked intense debates within legal circles.
I bet.
Is the operator on the ground mathematically more culpable than the financial backer? Or is capital inherently complicit? The legal strategies diverged based on the venue, but the ethical questions blanketed the entire consortium.
It's incredible to think about the timing here, because 2005 is a watershed year for this project. The lawsuit is settled, the legal precedent is cemented, and 2005 is the exact same year that Chevron formally acquires Unocal.
Yes.
So Chevron swoops in, buys Unocal's massive global portfolio, and in doing so, they inherit the stake in the Yadana project, and they inherit the immediate aftermath of this historic human rights settlement.
Chevron absorbs the asset, and the consortium moves forward.
And then the story kind of drops out of the Western headlines. The lawsuit is over, the pipeline is fully operational, the gas starts flowing under the Andaman Sea, crossing the jungle and feeding the Thai energy grid, and the money starts rolling in.
It does.
Which brings us to the next phase of this timeline. Let's fast forward a decade. We are now in the 2010s. What is the physical and economic state of the Yadana asset?
By the 2010s, Yadana had matured into an economic juggernaut. It is almost impossible to overstate its structural importance to the nation of Myanmar. Natural gas exports, the vast majority of which were flowing from Yadana into Thailand, had become the military junta's single largest source of foreign currency.
Let's break down the mechanics of why foreign currency is so vital, because if you are a military regime, you can print all the local currency you want to pay your soldiers basic salaries. But local currency doesn't buy things on the global market.
Exactly. The Burmese kyat is essentially worthless for international trade. If the military regime wants to purchase advanced weapon systems from Russia or China, if they want to import aviation fuel to run their fighter jets, or if they need to procure specialized technology to maintain their internal surveillance apparatus, they cannot use local currency.
Right.
They require hard, internationally recognized foreign exchange, specifically U.S. dollars or euros.
And the Yadana pipeline was a massive continuous geyser of U.S. dollars. How much money was actually flowing from this project to the state?
The historical analysis notes that the project was funneling over $1 billion a year directly to the state apparatus.
$1 million annually?
Yes. For a nation with a largely agrarian, severely underdeveloped economy, that is an incomprehensible financial lifeline.
That's everything.
That $1 billion in foreign exchange is the oxygen that allowed the military to sustain its apparatus of control. The Yadana project was no longer just an infrastructure joint venture. It had become the central financial pillar of the Tatmadaws power structure.
So you have TotalEnergies, Chevron, and PT-TEP essentially operating the financial life support machine for a military regime. Now, to be fair to the historical timeline, there was a period in the 2010s where the dynamic seemed to soften.
Yes, the democratic interlude.
Right. Myanmar went through a period of quasi-democratic transition. The military loosened its grip, a civilian government led by Aung San Suu Kyi was established, and the country opened up.
The geopolitical narrative certainly shifted during that window. Sanctions were eased, foreign investment flooded into the country, and for the energy corporations operating Yadana became far less politically radioactive.
The narrative was that their continued presence was helping to integrate Myanmar into the global economy and support its democratic transition.
Exactly.
But that narrative shattered instantly. The catalyst for the final chaotic act of the story hits in February 2021.
The 2021 military coup.
The exact same Tatmadaw that have been partnered on the pipeline for decades decides the democratic experiment is over. They violently overthrow the elected civilian government. They arrest the political leaders.
And the response was brutal.
Yeah, when the population rises up in massive nationwide protests, the military responds with absolute lethal force. They gun down protesters in the streets. They launch airstrikes on civilian areas. They reassert absolute brutal control over the country. And the entire world watches it happen in real time on social media.
And the moment the violence begins, the international spotlight pivots immediately and intensely back onto the Yadana consortium.
The public outcry was deafening. You have human rights organizations, international governments, and global activist networks all pointing directly at TotalEnergies and Chevron because the math was undeniable.
Right.
The partnership, which had always been legally fraught, was now fundamentally publicly indefensible. You cannot operate as a modern, forward-facing Western corporate giant, publishing ESG reports and tweeting about global human rights, while simultaneously managing an asset that is pumping $1 billion a year in hard currency to a regime actively bombing its own citizens.
It's completely incompatible.
The demand from the international community was singular and uncompromising. Shut it down. Cut off the money. Leave.
It represented an acute crisis of corporate diplomacy.
Yeah.
The moral imperative, as articulated by the international community, was unambiguous withdrawal.
Which introduces the central paradoxical dilemma of our deep dive today. Because standing on the outside as a consumer or an activist, leaving sounds like the obvious, morally pure choice.
Solve, walk away.
Right, you just pack up your briefcases, declare the regime illegitimate, and go home. But when you are quite literally physically fused to a state's strategic infrastructure, how do you actually leave without inadvertently making the situation worse?
This is where the abstract demands of global morality crash headlong into the rigid, unbreakable mechanics of corporate contracts and physical geography. The companies were trapped in a structure of their own making.
So what did they do?
Ultimately, the pressure became insurmountable. In early 2022, both TotalEnergies and Chevron formally announced their withdrawal from Myanmar. Total's exit became officially effective on July 20, 2022.
Okay, so the activists win, right? The Western giants bow to the pressure, they walk away, the bad guys lose their corporate backing, and the pipeline shuts down. Problem solved.
Not exactly. In fact, the mechanics of their exit created a deeply contested, highly complex outcome that we must examine closely.
Okay.
You have to understand that you cannot simply pack up a massive offshore drilling platform and hundreds of miles of pressurized steel pipeline and take it back to Paris or California. The infrastructure is permanent. It is geographically locked.
Right. You can't put a subsea manifold in your carry-on luggage. The physical pipeline stays in the Andaman Sea. The natural gas stays in the reservoir.
Exactly. And more importantly, the legal structure governing that infrastructure, the Joint Operating Agreement, or JOA, is also designed for permanence.
Let's talk about the JOA.
These contracts are specifically written to ensure that a multi-billion-dollar asset doesn't collapse just because one partner gets cold feet or faces political pressure at home.
So what happens when a partner wants out?
The contracts dictate a very strict procedure. When Total and Chevron decided to withdraw, they could not easily sell their shares to a more ethical buyer on the open market, because under the political conditions of a violent coup and impending international sanctions, no legitimate buyer existed.
Nobody wants to buy a pipeline from a sanctioned military junta.
Precisely. Furthermore, they could not simply shut off the valve and dismantle the project.
Why not? If you are the operator, why not just turn the key and power down the rig?
Because the Thai energy grid.
Oh, right, Thailand.
The gas from Yadana was absolutely critical to Western Thailand's electricity generation. Shutting down the pipeline wouldn't just hurt the Burmese junta. It would plunge millions of people in a neighboring allied country into darkness, devastating their economy. The geopolitical ramifications of unilaterally turning off the gas were catastrophic.
So they can't sell it and they can't shut it off. Their only option is to unilaterally withdraw and forfeit their equity. And here is where the legal trap of the Joint Operating Agreement snaps shut. I need to define a term here that is crucial to the dossier. Pro rata.
Yes, the pro rata distribution of shares.
Let's explain exactly how this works. It's like you are in a four-way business partnership and everyone owns 25% of a factory. You suddenly realize one of your partners is using their profits to run a violent crime syndicate.
Right.
You make the moral decision, I am out, I refuse to be associated with this. You stand up to walk out the door. But the contract you signed 30 years ago says that if you walk away, you don't get to take your machines with you. And you don't get to burn your 25% share.
No, you don't.
Your share is automatically divided pro rata, meaning proportionally, among the remaining partners who stay in the room.
That is precisely how the mechanism functions. Under the terms of the Yadana JOA, when Total and Chevron formally withdrew, their respective equity stakes in the project did not vanish. They automatically passed pro rata to the remaining partners in the consortium.
And who are the remaining partners sitting at the table when the Western giants walked out?
The Thai state firm, PTTP, which stepped up to take over the day-to-day operations from Total, and critically, MOGE, the Myanmar oil and gas enterprise, the state-owned entity entirely controlled by the military junta.
So, in the name of human rights, in an attempt to wash their hands of a brutal dictatorship, Total and Chevron essentially handed their multi-million-dollar equity stakes directly back to the very military regime they were trying to sanction.
This is the crux of the fiercely contested debate presented in the dossier. We must impartially examine both sides of this outcome because it highlights the structural impossibility of an ethical exit.
Let's look at the corporate defense first.
TotalEnergies and Chevron framed their withdrawal as a responsible, necessary, and legally constrained action in the face of an illegitimate regime.
Their argument is basically, we were trapped.
Precisely. Total argued that they spent months trying to find a legal mechanism to stop the revenue flow to the junta without physically cutting off the gas supply to the Thai energy grid, but that such a maneuver was legally and technically impossible under the existing contracts.
So they had to choose the lesser of two evils.
In their view, yes. Continuing to operate the field, continuing to be the entity actively turning the valve, and generating the revenue for the military became morally and politically untenable. Withdrawing, even knowing the contractual consequences of the pro rata distribution, was presented as the only ethical path forward. They refused to be the operators of the junta's ATM any longer.
I can understand the logic. If you are driving the getaway car, the first moral step is to take your hands off the wheel and get out, regardless of who jumps into the driver's seat after you.
Right.
But the pushback from the activist community on this was incredibly fierce, wasn't it?
It was. Organizations like Human Rights Watch, alongside numerous Myanmar civil society groups, had warned for months before the exit was finalized that simply walking away under the existing contractual terms would be a strategic disaster.
What was their argument?
Their argument was that by leaving and allowing the shares to automatically redistribute, the companies effectively transferred immense, unearned value directly to junta-controlled MOGE.
So the generals didn't just keep their revenue stream, they got a raise.
That is the activist critique. They argued that instead of cutting the junta's financial lifeline, the uncoordinated corporate withdrawal potentially increased the regime's total percentage take of the ongoing gas revenue.
Wow.
The companies abandoned the physical asset to protect their global public image, but the gas kept flowing into Thailand, the U.S. dollars kept flowing back into Myanmar, and now the junta earned a larger proportional share of that revenue stream.
The activists essentially argued that the companies prioritized their own ESG ratings over executing an exit that actually financially crippled the military. They wanted the companies to stay and actively sabotage the revenue flow, perhaps by putting the money into an international escrow account, defying the contracts entirely.
Which the companies argued would invite massive legal retaliation and still potentially disrupt the Thai power grid.
It's a lose-lose.
It is a completely paradoxical outcome. You leave to stop funding the bad guys, and the mechanical reality of your departure ends up enriching them further.
If we pull back and synthesize this entire timeline, it brings us to the core thesis of the Global Blueprint Archives. It forces us to confront an open-ended modern dilemma. How does a massive multinational corporation responsibly leave a place it perhaps never should have entered to begin with?
That's a huge question.
If staying means you are actively complicit in funding a regime, and leaving means you structurally enrich that same regime, what is the third option?
It is arguably the defining challenge of global corporate governance in the 21st century. The legal frameworks we currently have, even with the massive historical advances of Doe v. Unocal, are fundamentally ill-equipped to handle the messy, physical reality of infrastructure abandonment.
Right.
Contracts are written for stability and profit, not for human rights crises.
We have covered an immense amount of historical and legal ground today. Let's briefly recap the causal chain of this incredible journey. We started in the geopolitical isolation of the 1990s, looking at how the necessity for massive capital expenditure drove the creation of a multinational joint venture between Western energy giants and the Burmese military regime.
We then examined the physical reality of the Yadana pipeline, detailing how the military of the Tatmadaw acted as a brutal private security force. They utilized systemic forced labor and committed documented atrocities against the Karen minority simply to clear and secure the corporate corridor.
Which directly triggered the reckoning. We unpacked how those villagers utilized a 1789 piracy law to file the Doe v. Unocal lawsuit. That case shattered the historical illusion of corporate immunity, establishing the vital precedent that a company could be held liable in U.S. courts if it merely knew and benefited from the human rights abuses of its sovereign partners, permanently altering modern corporate litigation.
And finally, we tracked the assets' growth into a billion-dollar financial lifeline for the regime. We saw how the 2021 military coup triggered a massive international outcry, ultimately forcing Total and Chevron to withdraw in 2022.
Yeah.
But we analyzed the paradoxical reality of that exit, a withdrawal governed by ironclad joint operating agreements that ultimately distributed the abandoned shares pro rata, leaving the junta with an even larger piece of the revenue pie.
Which brings this entire massive history right back to you, the listener, because a pipeline in the Andaman Sea might feel incredibly distant, but it matters to you today. The Yadana project isn't just an isolated historical anecdote. It is the ultimate blueprint for understanding the hidden costs of global infrastructure.
Exactly.
The device you are listening to this deep dive on, the electric vehicle you might drive, the energy grid that powers your city, all of it relies on global supply chains that are actively grappling with these exact same questions of state power, corporate complicity, and the sheer structural difficulty of ethical extraction.
The physical infrastructure of our modern world is deeply intertwined with complex, often compromised political realities. The supply chain is rarely as clean as the finished consumer product.
And so I want to leave you with a final lingering thought to mull over, something that builds on the permanence of what we've discussed today. We talked heavily about how Total and Chevron walked away, legally severing their ties and leaving their shares on the table. But think about the physical pipeline itself, that steel buried deep in the jungle.
It's still there.
Right. When the very infrastructure that powers our modern, comfortable world is fused to regimes that suppress human rights, where does corporate responsibility actually end? Does it cleanly end the moment a company signs a piece of paper forfeiting its shares? Or is a corporation forever morally tethered to the physical foundation it paid a military to build?
It is a question that the legal system has not yet answered. But as global consumers, it is a question we must continuously ask.
Thank you so much for joining us on this massive deep dive into the global blueprint archives. We hope it gave you some profound insight into the heavy mechanics of how the world actually operates. Keep questioning the hidden histories behind the global economy, keep looking at the blueprints beneath the surface, and we will see you on the next deep dive.